This evening, the travesty of justice in the Bilkis Bano case in Gujarat. I'm Barkhatat, here with the Mojo story. I met Bilkis Bano in a relief camp in Godhra in 2002. She was only 21 years old. She was 5 months pregnant when she was gang raped. And that was not the end of her horror. 3 other women, including her mother, were also gang raped. In fact, her mother and she were gang raped in front of the other. They were forced to witness this. And the worst was yet to come. As the women lay bleeding and helpless on the floor, Bilkis's 3-year-old daughter Saleha was killed by the same men who used a stone to smash her head. Bilkis Bano and her husband Yaqub fought 17 years and did not give up to secure justice and get the men who did this convicted. The Supreme Court, no less, ordered 50 lakhs as compensation to the family in 2019. Remember, this was a young woman who lost her child, who was gang raped, whose arm was broken when I met her. I can never forget that image, I think, for as long as I live. And she saw her child die. And these were men known to her. Many of them used to buy milk from her and her husband's family. But just as she thought that she had fought hard and secured justice, came the rude shock in Gujarat. 11 men who did this to her have walked free. Yes, you heard that right. They have walked free as part of a special prisoner remission program. One of them petitioned the Supreme Court. The Supreme Court referred it back to the Gujarat government, and the Gujarat government then decided to set these men free. Is this in contradiction of the center's own guidelines, or has the center actually endorsed this decision? These are the images, meanwhile, you saw outside prison today. The 11 convicts distributing sweets, being greeted, getting hugs. As Bilkis's husband, Yaqub, told me, the family is sad, scared, and in shock, and that they had no idea this was coming. They only heard about it from the media. Our guest today is Vrinda Grover, who's of course a senior advocate, one of our best-known lawyers, as well as a tireless voice for those who don't have one. Vrinda, thank you. This case actually feels personal. I was a very young reporter when I met Bilkis Bano in a relief camp in 2002. That image stays with me. It haunts me. When you see this happen as a lawyer, as a woman, what is the first thing you're thinking today?
What one sees as a lawyer is, as you mentioned, this is a travesty of justice. It's a grave miscarriage of justice. The state, the law has convicted these men, not just of murder and gang rape, murder of the daughter and gang rape of Bilkis, but 7 other women of her family were raped in front of her. Many members of her family were killed. A 3 or 2-day-old child, baby, was killed, and they were all targeted due to their Muslim identity and attacked by persons and all men known to them. The courts have therefore convicted as well as penalized through fine, etc. The state is always given discretion to be exercised in a manner which is judicious, fair, reasonable. What we are seeing today is that the state itself has become a majoritarian state. And I say this with a lot of responsibility. The release of these 11 convicts is not an act of reformation. Let us make no mistake about that. This is an act of a majoritarian state signaling impunity for crimes targeting some citizens of India. And that is the messaging that has happened. And in my view, the state has acted arbitrarily, in a discriminatory manner, and this cannot be countenanced by the law of the land.
When you say that this is the action of a majoritarian state, that is in a way a political statement. But what is the legal position? And I ask you this because there's a degree of confusion over whether the Gujarat government has contradicted the centre's own guidelines. And if we just pull up that graphic for the benefit of our viewers, the question is whether the Gujarat government and the central government are on the same page. Earlier this year, the center actually released new guidelines for special prisoner release or remission. But under this, Vrinda, as you would know, rape was among the heinous crimes that was excluded from those convicts who can ask for early release. And there were other crimes listed as well, including terrorism, the POXO Act, hijacking, and so on. These are all excluded from the ambit of special prisoner release or remission. So I have to ask you legally, is the Gujarat government in contradiction of the Home Ministry's guidelines? What's actually going on here legally?
So let's see, what does the law say? The law says that the chapter from section 432 onwards deals with remission. It is an important part of any penal system where the state should have the power to allow release. And here also they've been released after 14 years. We must put that on record. Under section 435, if a case has been investigated by the CBI, this particular case was investigated by the CBI. Section 435 of the Code of Criminal Procedure deals specifically with cases investigated by the CBI, and it says that the power of remission that is awarded to the state government in a case investigated by the CBI shall not be exercised by the state government except after consultation with the central government. So when I say state here, I mean the state of Gujarat, the government of Gujarat, as well as the central government. This decision could not have been taken and to reward them with remission except with the mandatory consultation with the central government and therefore the Ministry of Home Affairs. The Ministry of Home Affairs has put out these guidelines. Even in the new circulars issued for release of prisoners on 15th August 2022 as well as 15th August 2023, the Ministry of Home Affairs is very categorical that rape convicts will not get the benefit of this policy. Let us also then look at the law. What does the law say? There is a judgment. These accused men had gone to the Supreme Court. The Supreme Court had said, and this is a law for long, that the policy that will apply will be the policy that was in place at the time of conviction. This conviction for the first time takes place in Bombay, where, if we recall, the trial had to be transferred as there was no hope of a fair trial in the state of Gujarat. The Supreme Court transferred the trial. The Bombay Sessions Court convicted these men in 2008. The policy of remission, which is the state of Gujarat policy, applicable on them, is a policy which dates back to 1992. To the best of my knowledge, that policy is nowhere available in the public domain today. And perhaps the state of Gujarat would be kind enough as a state to inform us as citizens by putting up that 1992 policy under which this remission has been granted.
Can I ask you something? Can I ask you something? I just want to make this simple for the audience that doesn't really understand the intricacies of law. I was under the impression till I started speaking to you that the Gujarat government and the central government were contradicting each other. You're actually saying that these guidelines that have come this summer that actually propose prisoner release, early prisoner release, but exclude crimes like rape are new. And that in your understanding, under the old law, Gujarat could not have released these 11 men without the specific approval of the center. Am I understanding you correctly?
Yes, section 435 of the Code of Criminal Procedure, because this particular incident, crime, was investigated by the CBI. Therefore, section 435 CRPC comes into play, which, and I read again, that the powers conferred to remit or compute a sentence to the state government shall not be exercised by the state government except after consultation with the central government. So the central government has endorsed, approved, affirmed this remission. The same central government which puts out a policy saying no rape convict is to be
So,
enlarged on remission.
so in other words, it isn't Gujarat that has contradicted the center, it is the center that has contradicted the center.
The center that has betrayed the women of this country, yes.
So I'm just going to recap this simply. You are saying that the law specifically says that Gujarat's government could not have released these 11 men seen distributing sweets outside prison today without the approval of the same center that just recently proposed that rape be the crime excluded from the ambit of such special releases. So how can the center hold both views? It's confusing.
It's not confusing. I think that's why it would be. So let me just make this a little clearer. There is a 1992 policy which is not in the public domain, at least not to my knowledge. It may be with others, which would govern the remission. I don't know what is written in it. Most remission policies, I have had the occasion to appear in a matter relating to Rajasthan, exclude heinous crimes, grave crimes. This particular incident is what would, in international criminal law, be described as crimes against humanity when this kind of targeting and killing and gang rape takes place. So any policy would actually exclude heinous crimes of this nature. Because it is CBI investigated, the state government, which is the state of Gujarat, which would apply the 1992 policy, cannot take this decision exclusively by itself. The Code of Criminal Procedure, which is the ordinary law of the land and whose writ will run, compels them to take this decision after consultation with the central government. Of course, they also have to take the opinion of the sitting judge who convicted, etc. None of those documents are before us. We don't know how this decision was arrived at, but the law is very clear and there's no confusion. Therefore, this is not something that the center can say, I have no role to play. We don't know what the state of Gujarat does. State of Gujarat has taken this and you can't shirk. You have approved, affirmed this decision. Your consultation was mandatory. And therefore, for the center to then say that they have no role to play in this would be contrary to the law. And what does the law say? Let me read out further from another judgment of April 2022 of the Honorable Supreme Court. It says, while a discretion vests with the government to suspend or remit the sentence, the executive power cannot be exercised arbitrarily. The prerogative of the executive is subject to the rule of law and fairness in state action embodied in Article 14 of the Constitution. This court has held that the power of remission cannot be exercised arbitrarily. The decision to grant remission should be informed, fair, and reasonable. So simply because you have a power, you don't get to exercise it arbitrarily. And I don't know whether arbitrariness even covers what this remission has actually resulted in. And this particular decision is subject to judicial review. It can be challenged in a court of law, and a court of law can see whether this decision is fair, just, reasonable, or whether the state has abused the power and the discretion that was awarded to it. So I don't
Well,
think we last.
yeah. So the last word may not have been spoken, we hope, but yet I think of this family that has actually fought for 17 years, changed 20 homes along the way, had to live outside of their home state. And remember, these men who have been released are all known to them. These are not strangers. These were neighbors. Yaku, Bilkis's husband, I spoke to him earlier today and he said, we're scared, we're shocked. We had absolutely no idea. We also learned of this from the media. Now, my question to you is this. When you say that it is open to judicial review, would it have to be Bilkis Bano, who having fought for 17 years, having only been promised her compensation of 50 lakhs in 2019 by the Supreme Court, is it her who will have to go back to court again?
You know, this question is very relevant today in India for a number of reasons. So the state of Gujarat is obviously not going to go because the state of Gujarat has abused the power that is awarded to it under law. The central government has in consultation agreed to this arbitrary, discriminatory release. So Bilkis should go. Perhaps a human rights defender, an activist, will support her. What has the Supreme Court's messaging been to human rights defenders and activists who have stood up and walked the difficult, arduous legal journey? What has the Supreme Court said? And what has the Supreme Court done to those activists? Those citizens who are public spirited, who will stand by and walk this journey, which these women and men may not be able to walk alone. What is the messaging that has gone in judgments of the Supreme Court recently? This is why those human rights defenders are needed. This is why those activists are needed, because these journeys against the might of the state, against a majoritarian state, cannot be undertaken in a court of law alone by the victim survivor. We know that.
Yeah, I am also struck by the irony that we are a country where there's a ferocious debate, for example, about death sentence and gang rape. And this law was amended after, as you know, by the Justice Verma Committee in the aftermath of what came to be known as the Nirbhaya gang rape. Why is that outrage that we saw for a Nirbhaya not there for a Bilkis Bano? Why is it not there? Why is the middle class outrage that is able to, almost emotionally and morally justify and encounter death, let's say, of a known rapist or an alleged rapist? Where is that outrage today? I mean, are you not struck by Vrinda by these ironies?
Absolutely. Since morning, this is a thought that has been running through my mind. I have, as a lawyer and as a feminist and a human rights crusader, always said no to death sentence for every single crime, including rape and murder. I've also said incarceration, long incarceration is not a policy, is not a way forward. This for remainder of natural life, etc., should not be the policy. However, courts have held that collective conscience has been satisfied. So where is that collective conscience today? Where is that anger against rape? It was never the anger against rape. And that is what we have been saying since 2013. That since the Nirbhaya gang rape, that this anger and seeking death sentence, castration, all manner of further violence is not for women. It is not an outrage against violence against women. It is only to strengthen the arm of the state and create a society that is even more violent. Otherwise, why is everybody not today saying, how did these gang rapists and gang rapists known to you? For Nirbhaya, there was much cheer when people were hanged. I've appeared against that death sentence. Today, actually, the hypocrisy stands totally exposed, not only of the state, but of the people of this country. And they will have to do some reckoning. They were not standing up for women. Let us not fool ourselves anymore. But what is the state doing in the middle of all this is the crucial question. Can the state start acting when the state is acting in a partisan manner, deploying the power it has under law? Then what is to be done is a question the court will now have to ask itself.
But just like you are pushing back against the double speak on death sentences, let me push you a little bit on this idea of life imprisonment. You say, as a human rights crusader, you actually don't believe in life for life. So some might ask you, why then are you so angry about what's happened in the Bilkis Bano case? After all, these men had served 14 years. It's when one of them went to the Supreme Court and said, we've served 14 years, that this sentence was relaxed, as it were. If you are principally opposed to the idea of life imprisonment, meaning for the rest of your adult life, why are you also opposed to the verdict in this case? Or rather, the decision, the executive decision in this case?
To answer this question. And this is what I began with. What we are seeing manifest through this case and release of these 11 men today is not an act of reformation. We call prisons in India correctional homes. We know they are not. Should they be? Absolutely yes. The point is, who will get the benefit of that remission? When the state ceases to act in a fair, even handed manner, I will not be blind and say, oh, this is reformation because people have come out of after 14 years. Then let the policy be for all to come out of 14 years. You cannot have a system which is going to act in a discriminatory manner. This is not arbitrary, this is discriminatory. Therefore, this act is not an act of reformation, it is the pinnacle of state impunity in a country where there is targeted violence that was committed. So, this cannot be, you have to reconcile the power of the state with what is happening. It is a matter of record by the NCRB that the largest number of people languishing in jails in this country are Adivasis, Dalits, and Muslims. So, what is that telling us about the system? That the system is just doing its job and this is incidental? No. And therefore, I will not accept this as reformation. I will see this as an act of state impunity and therefore hold the state to account.
Yeah. Let's before we end go back to the plight of the family, to think of this young woman, 5 months pregnant, gang raped, watching her mother gang raped, other women, loses 14 members of her family. Her husband, who I spoke to, has released so far a short statement to the media. I just want to play that out, where he explains, he's speaking in Gujarati, we have translations, that he had no idea and the family is somewhat in a state of shock. Listen.
યાકુબભાઈ બિલકિસ બાનોના હસબન્ડ. હાલ હું યાકુબભાઈ બિલકિસના તરફથી કે જે કાલે જે ચુકાદો આવ્યો સ્ટેટ ગવર્મેન્ટે, જે 11 આરોપીઓને બિલકિસના સામૂહિક હત્યાકાંડની અંદર જે સંડોવાયેલા આરોપીઓ જે ને છોડી દેવામાં આવ્યા, એના અનુસંધાનમાં હાલ અમારી પાસે મીડિયાના માધ્યમથી ખબર આવી કે આ વસ્તુ થઈ છે. ત્યાર સુધી અમને કોઈ જાણ હતી નહોતી. લીગલ અમારી પાસે કોઈ પેપર કે કોઈ નોટિસ સરકાર તરફથી કે કોઈની જગ્યા પરથી અમારી પાસે કશું આવ્યું નથી. એ લોકોએ જાતે એમના પોતે નિર્ણય લઈ અને છોડી મૂક્યા છે, એટલી જ અમને ખબર હાલ છે. અને હાલ એ ખબર સાંભળવાથી અમને એટલું બધું દુઃખ અને એક માયુસ થઈ ગયા છે કે અમે આટલા લાંબા સમયથી લડાઈ લડી એનો આ નતીજો છે. એટલે અમને બહુ દુઃખ અને ડર જે ઓછો હતો એ આજે વધી ગયો છે.
સરકાર તરફથી તમને જે સહાય કરવામાં આવી છે એ મળી છે કે નહીં?
સરકાર તરફથી જે સહાય કરવામાં આવી છે, 50 લાખ રૂપિયાની જે સહાય છે અમને ચૂકવી દેવામાં આવી છે. અને સરકાર, સુપ્રીમ કોર્ટે જે સરકારને આદેશ કર્યો છે કે એક મકાન એમને આપવું જોઈએ અને નોકરી આપવી જોઈએ, એના વિશે હજુ કોઈ નિર્ણય નથી થયો.
Okay, so quite simply, Vrinda, he's saying that they had no idea. They read about it from the media, that his wife and he are mayus. They're deflated, they're demoralized. They were given no paperwork, no legal intimation, nor their lawyers. The reporter there asks, what about the role of the state? Has the state helped you? And he says, well, the 50 lakh compensation came to us from the Supreme Court. We were also promised a house and a job, but there's still to be movement on that. We are deflated because we fought 18 long years to get to this point. Do you believe the Supreme Court could on its own suo moto at least? I mean, if I'm Bilkis today, I'm thinking these men are my neighbors. They know me. I know them. I'm going to be mortified. I'm going to be physically scared. I'm going to be emotionally traumatized. Can the Supreme Court take some kind of suo moto intervention here?
You know, I would never try to second guess what the Supreme Court of India will do. What I do know is that they have the power. I know that the judicial review power exists over this order. That order has to be a reasoned, detailed order saying why they feel. See, it's very interesting. All 11 men have been given remission after 14 years, which is the minimal before which remission is not permitted under law. So the first count when remission was available under law, all 11 have been given. So are we to believe that all 11 of them have expressed remorse, regret what they have done, understand that targeting members are simply on the basis of their religion killing your neighbors, gang raping them, killing babies is all very heinous crime. All 11 have come to this enlightenment, and on that basis, remission has been given. These are factors of judicial review. See, the point is, how do citizens of this country, how do women of this country continue to have hope? Simply saying, give them respect, samman, all this sounds very good. But where does samman come? What does an order like this do? It's not just about those 11 men. It's a messaging that the state gives to society, that you may have committed crimes, that nothing can be more despicable than these crimes, Barkha. You pursued them, you chased them, you targeted them and hacked them and raped them. What can be more despicable?
Yeah.
And what is the messaging that the state has given to us? It's not just about the order. And Bilkis, for me, will always remain an inspiration, because to fight against the might of this state, a state that is increasingly majoritarian, and majoritarian penal state is where the anxiety comes from. It is for other institutions now to put a check on this power.
Yeah. We end this broadcast with thoughts with Bilkis Bano, a woman who has, as Vrinda Grover said, fought for years, literally for years, 18 long years, to put these men behind bars. The same men have walked free today. But as Vrinda Grover reminds us, there is still judicial review possible, and it doesn't have to be Miss Bilkis Bano who goes to court. It can be a lawyer, an activist, or the court itself. As Vrinda, you said, maybe, just maybe, there will be some sort of revulsion at what has happened and the thought of these men out. I don't know, but we have to keep hoping. Thank you very much, Vrinda Grover, for talking to us. Take care.
Thanks.
Thank you.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.